Hey there, I'm estate planning attorney Paul Rabelais, and in this video I'm going to describe what happens in the world out there when it comes to trustee compensation. So there are all different kinds of trusts and there's different kinds of trustees, but in this video we'll discuss the typical trustee arrangements when the settlor, often a parent, or the settlors, often a married couple, has passed away and they had created a revocable living trust, and now it's time for that successor trustee to distribute the trust assets to the trust beneficiaries. This trustee compensation could also apply to the type of trust that exists when someone, for example, bequeaths a sum of money for, let's say, $500,000 to, let's say, their grandchild in trust, and a trustee must manage those trust funds until the grandchild reaches an age much later in life. The difference between the two is that a successor trustee making distributions from a revocable living trust after a settlor dies is often a one-time event, while a trustee managing the grandchild's hypothetical $500,000 trust for years or decades can involve recurring trustee fees each year. So this can be a tricky one, and I feel like I first need to describe the differences in compensation between the executor or administrator of a probate estate and the compensation of the successor trustee of a revocable living trust. People die every day and they don't have a living trust. Some people leave all of their assets in their name, and when they die, there's a probate required who oversees the estate settlement through the court system. If the person who died had assets in their name and they had a will, the person named in the will to oversee the estate settlement is called the executor, or in some states they're called personal representative. If a person dies with probate assets in their name and they don't have a will, then a judge will typically appoint an administrator. Same job as the executor, just a different title. And in each state's probate rules, it typically states clearly how much compensation that the executor or administrator is entitled to receive. Sometimes it's a fixed percentage of the estate assets, and some states have a sliding scale where the percentage goes down as the fair market value of the estate assets goes up. And for kicks, let's say that percentage compensation that the executor or administrator of a probate estate is 3%. So if you apply a 3% compensation rate to a $2 million estate, that executor compensation would be $60,000. But what if you've done the legwork to keep your estate out of probate? You set up your living trust, you transferred your probate assets to that living trust, and there's no probate when you die. Well, even though there is no court and attorney involved probate, a successor trustee, you're the initial trustee, but you died. A successor trustee is required to effect the transfers from the trust to the trust beneficiaries. And again, these distributions are done outside of court and attorney involvement. So what kind of compensation is that successor trustee entitled to? Well, this is an area that is really vague. And when things are vague, when people are sharing a big pot of money, that could lead to stress, animosity, and hard feelings. And the reason trustee compensation is vague is because, unlike executor compensation, where you just apply the probate statute and do the math, with trustee compensation, most state trust codes and most trust instruments provide that trustee compensation must be reasonable. And trustees and beneficiaries often have a different interpretation of what is reasonable compensation. So serving as a trustee of a trust can be a huge responsibility, and trustees should be entitled to compensation for their work, unless, of course, the settlor expressly provides in their trust instrument that the trustee shall serve without compensation. And if you provide in your living trust that your successor trustee shall serve without compensation, you'll likely provide that they're entitled to reimbursement for expenses they incur. After all, if you leave your $3 million living trust equally to your 3 children, then it's probably not a big deal that one of them serves as your trust's successor trustee without compensation. They're receiving a $1 million inheritance from the trust. And since generally an inheritance is income tax-free, and trustee compensation is taxable income, less tax will be paid if the trustee receives no compensation. But if a trustee is entitled to reasonable compensation, as is often the case because the trustee compensation is often not otherwise addressed in the living trust, then perhaps the amount of compensation depends on the type of trustee and the complexity of the trust. A living trust's successor trustee's duties can include managing trust assets, making distributions to beneficiaries, paying taxes, creating an annual report of all income and distributions. Performing these tasks can involve a lot of work, so it's not unreasonable that a trustee be compensated for their time, effort, and expertise. Now, while large trust companies have the ability and capacity to serve as the successor trustee of your living trust, it's not common. More often than not, people select an individual or individuals to be the successor trustee or co-trustees of their living trust. It's quite often one or more of the settlor's adult children who are also beneficiaries of the living trust, or it could be a friend, relative, or other acquaintance of the settlor, which is often the case when a parent or parents are not comfortable with the relationship dynamics that occur when one of the children is designated as the successor trustee. So when a corporate trustee serves as the successor trustee of your living trust, which is not common, but you see it sometimes in the $10 million plus estates who can justify the corporate trustee expenses, it's common that the corporate trustee will typically have their own written and published fee schedule. That compensation is usually based on a sliding scale, and for purposes of our discussion, that corporate trustee compensation might be 1% to 2% of the value of the trust assets. And if the trust goes on for more than a year after the settlor dies, these fees are likely to be recurring each year. But again, most living trusts are settled by an individual trustee as opposed to a corporate trustee. So what is reasonable compensation for an individual living trust successor trustee? I'll give you the lawyerly answer. It depends. But I don't want to give you the lawyerly answer. So let's start with perhaps reasonable compensation for an individual trustee would be maybe half of what the corporate trustee would charge. You see, an individual is likely to farm out certain administrative tasks like trust accountings, where a corporate trustee will absorb that expense. But whatever that individual trustee compensation winds up being, if the other beneficiaries of the trust think that the compensation that the trustee paid themselves is excessive, those other beneficiaries have recourse through hiring lawyers and taking the trustee to court to force the trustee to prove to a judge why their compensation is reasonable. But that kind of trust challenge can be expensive and an all-around pain in the you-know-what. So if you're a hardworking American who just wants to keep what you have and pass it along to your family or loved ones in a way that is not a burden but a positive and impactful inheritance, then here's how you address an individual trustee's potential compensation that they'll be entitled to after you pass away. You should probably have a conversation with the successor trustee of your living trust so that the two of you can communicate your thoughts on a variety of topics, not only their trustee compensation, but perhaps conversations about which assets get sold or distributed in kind, how personal items or tangible property gets distributed, and other matters where the trustee may have the ability to exercise some of their own discretion. If you're confident that the trustee is not interested in compensation, either because they're already a trust beneficiary or because they consider it an honor to be the trustee and they have no interest in compensation, or both, then maybe you don't need to address it. Or if you're not sure, maybe you say in your trust instrument that the trustee is not entitled to compensation. But if in the back of your mind you wonder whether that trustee you chose just might decide after you die to milk that trust for as much compensation as they can get, or maybe that trustee is married to someone or could get influenced by someone to make some bad trustee decisions, but you feel like you need to name them as the trustee because they're the best selection of your available alternatives, then maybe you specifically address the topic of trustee compensation by designating a certain dollar amount of trustee compensation, or by stating that any individual trustee shall serve without compensation. This could eliminate the squabble in the event your trustee exercises discretion that they have to take some significant compensation when beneficiaries feel like the trustee abused that discretion. You surely don't want your heirs to never speak to each other again over a matter like trustee compensation. So if you feel you need to get your estate legal affairs in order, you can click the link in the description below and request a no-expense Zoom estate planning design meeting with me, where we'll explore what you want to accomplish from an estate planning perspective and figure out the most efficient way to accomplish it through my national estate planning law firm, America's Estate Planning Lawyers. Now go ahead and have a great day.